Hello and welcome to the Minimum Competence episode for Thursday, May 1st, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, Apple facing contempt, a Palestinian student's free speech win, Meta's AI copyright clash, and the Supreme Court is divided on religious charter schools. Let's remember, if you always do what you've always done, you'll always get what you've always got. And read today's legal news. On this day in 1958, President Dwight D. Eisenhower issued a proclamation that did more than just slap a new label on the calendar. It attempted to reframe the ideological narrative of the Cold War itself. With Presidential Proclamation 3221, Eisenhower officially designated May 1st as Law Day, a symbolic counterweight to May Day, the international workers' holiday long associated with labor movements, socialist solidarity, and, in the American imagination, the creeping specter of communism. What better way to combat revolutionary fervor than with a celebration of legal order? Pushed by the American Bar Association, Law Day wasn't just a feel-good civics moment, it was a strategic act of Cold War messaging. While the Soviet bloc paraded tanks through Red Square, the U.S. would parade its constitution and wax poetic about the rule of law. In short, May Day was about the workers, Law Day was about the lawyers, and the system they claimed safeguarded liberty. But this wasn't just symbolic posturing. In 1961, Congress gave Law Day teeth by writing it into the U.S. Code in 36 U.S.C. Section 113, mandating that May 1st be observed with educational programs, bar association events, and a national reaffirmation of, quote, the ideal of equality and justice under the law. Cynics might call it Constitution cosplay, advocates call it civic literacy. Either way, Law Day has endured. Each year, the president issues a formal proclamation with a new theme, ranging from the judiciary's independence to access to justice. The ABA leads events, schools hold mock trials, and the legal community gets a rare day in the spotlight. In the grand tradition of American holidays, Law Day may not come with a day off or department store sales, but it's a reminder that the U.S. doesn't just celebrate its laws when it's convenient, it does so deliberately and sometimes geopolitically. A federal judge ruled that Apple violated a 2021 injunction meant to promote competition in its App Store by improperly restricting developers' payment options. U.S. District Judge Yvonne Gonzalez-Rogers found that Apple defied her prior order in an antitrust case brought by Epic Games, the maker of Fortnite. The judge referred Apple and its vice president of finance, Alex Roman, to federal prosecutors for a possible criminal contempt investigation, citing misleading testimony and willful noncompliance. She emphasized that Apple had treated the injunction as a negotiation rather than a binding mandate. Epic Games CEO Tim Sweeney praised the ruling as a win for developers and said Fortnite could return to the App Store soon. Apple had previously removed Epic's account after it allowed users to bypass Apple's in-app payment system. Despite the ruling, Apple maintains it made extensive efforts to comply while protecting its business model and plans to appeal. Epic argued that Apple continued to stifle competition by imposing a new 27% fee on external purchases and deterring users through warning messages. The judge rejected Apple's request to delay enforcement of her ruling and barred the company from interfering with developers' ability to communicate with users or imposing the new fee. Palestinian student Mohsen Madawi, a Columbia University graduate student and longtime Vermont resident, was released from U.S. immigration custody after a judge ruled he could remain free while contesting his deportation. The case stems from the Trump administration's efforts to remove non-citizen students who have participated in pro-Palestinian protests, arguing such activism threatens U.S. foreign policy. Madawi, who was arrested during a citizenship interview, has not been charged with any crime. Judge Jeffrey Crawford found he posed no danger or flight risk and compared the political environment to McCarthy-era crackdowns on dissent. Crawford emphasized that Madawi's peaceful activism was protected by the First Amendment even as a non-citizen. Madawi was greeted by supporters waving Palestinian flags as he denounced his detention and vowed not to be intimidated. The Department of Homeland Security criticized the decision, accusing Madawi of glorifying violence and supporting terrorism, although no evidence or charges of such conduct were presented in court whatsoever. Members of Vermont's congressional delegation condemned the administration's actions as a violation of due process and free speech. Madawi's release was seen as a symbolic blow to broader efforts targeting pro-Palestinian foreign students, while others in similar situations remain jailed. Columbia University reaffirmed that legal protections apply to all residents, regardless of citizenship status. The relevant takeaway here revolves around the First Amendment rights of non-citizens. Judge Crawford's ruling affirmed that lawful non-citizens enjoy constitutional protections, including freedom of speech. This principle was central to Madawi's release, reinforcing the legal standard that political expression, even controversial or unpopular, is not grounds for detention or deportation. A federal judge in San Francisco is set to consider a critical legal question in ongoing copyright disputes involving artificial intelligence, whether Meta Platforms made fair use of copyrighted books when training its Llama language model. The case, brought by authors including Junot Diaz and Sarah Silverman, accuses Meta of using pirated copies of their work without permission or payment. Meta argues that its use was transformative, enabling Llama to perform tasks like tutoring, translation, coding, and creative writing without actually replicating or replacing the original works. The outcome could significantly impact similar lawsuits filed against other AI developers like OpenAI and Anthropic, all hinging on how courts interpret fair use in the context of AI training. Meta contends that its LLM's use of copyrighted material is covered under fair use because it generates new and transformative outputs rather than duplicating the author's content. Plaintiffs argue that this type of use violates copyright protections by extracting and repurposing the expressive value of their works for commercial AI systems. Technology firms warn that requiring licenses for such training could impede AI innovation and economic growth. Authors and content creators, on the other hand, view the unlicensed use as a threat to their financial and creative interests. The U.S. Supreme Court appears sharply divided over whether states can prohibit religious charter schools from receiving public funding in a case that could significantly alter the legal landscape for church-state separation in education. The case centers on Oklahoma's rejection of St. Isidore of Seville Catholic Virtual School's bid to become the first publicly funded religious charter school in the country. Conservative justices, including Brett Kavanaugh, expressed concerns that excluding religious schools constitutes unconstitutional discrimination, while liberal justices emphasized the importance of maintaining a secular public education system. Chief Justice John Roberts is seen as a crucial swing vote. He questioned both sides, at times referencing prior rulings favoring religious institutions, but also signaling discomfort with the broader implications of authorizing religious charter schools. Justice Sotomayor raised hypothetical concerns about curriculum control, such as schools refusing to teach evolution or U.S. history topics like slavery. The case could affect charter school laws in up to 46 states and has implications for federal charter school funding, which mandates non-sectarian instruction. Justice Amy Coney Barrett recused herself, increasing the possibility of a 4-4 split, which would leave Oklahoma's decision to block St. Isidore intact without setting a national precedent. As we've mentioned, this case hinges on the constitutional balance between prohibiting government endorsement of religion, that's the Establishment Clause, and ensuring equal treatment of religious institutions, that's the Free Exercise Clause. The justices' interpretations of these principles will guide whether public funds can support explicitly religious charter schools. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, you cannot solve a problem with the same mind that created it.